so excited to have this guest today. We have such many wonderful guests on this show that agree to say yes because we do need each other. And this man that we have today has a wealth of information that we need to know and understand his perspective and just champion him for the work that he's doing in the world. So let me introduce to you Eric J. Miller. He is a professor and Leo J. O'Brien Fellow at Loyola Law School in Los Angeles, California, where he teaches and writes in the areas of criminal procedure, jurisprudence, critical race theory, reparations, and problem solving courts. Professor Miller is a former chair of the AALS section on criminal justice and a co editor of the Cambridge Handbook on Policing in America 2019, as well as co-founder of the Policing Los Angeles Forum, which brings legal academics, law enforcement, personnel, lawyers, policymakers, and activists together to propose innovative policing reforms. Yay! His scholarship focuses the intersection of criminal justice with political theory, sociology, and criminology. Professor Miller is an internationally recognized expert on problem solving justice and specialty courts, as well as on the police and policing and on reparations for African Americans. He has provided testimony to the United States Congress, House Judiciary Committee, the United States Sentencing Commission, the Federal Judicial Center's National Workshop for U.S. Magistrate Judges, the Eighth Circuit Chief Judges Conference, and internationally to the Scottish Commission on Women Offenders and the Scottish Government Judicial Studies Committee. There is just so much more that I could say about this amazing man. Look him up and learn more, because we have a lot of talking to do because he has such a wealth of information. Welcome to this episode, Eric.
Thanks so much.
I'm so happy to have you with us.
Yeah, I'm really looking forward to the conversation.
It came to be, besides all this other information that Eric has that we will talk about today, but a couple of months ago, we had an episode with two members of the Black Law Student Association, Nikki and Beatrice from Loyola Law School, and they talked about some demands that they had made of the university and a recognition that there were some racial issues at the school in a great deal in what was not being taught in the classroom. You know, I think it was Nikki said that she took criminal justice, and how can you teach a criminal justice class and not talk about race? And race was just never spoken, or if it was brought up, it was kind of on the surface and nothing ever went deep. And they're wanting to see in this particular time that we're living in a deeper resolution to the world that we are living in, which in my humble opinion, and Eric, you can help me with this, I believe that law professors are just extremely important right now because they are shaping young minds. They're teaching them about what is really true as they go into these different areas of law, and to see what they're really looking at, because we have lived in a system that has been through a particular gaze and has looked at criminals as looking in a certain way, which is, you know, just not the makeup of every person. So that's my opinion. I have nothing to do with law. I'm not I'm not a professor of any sort. I'm not in the law school, but it's just a thought that's come to me. So I'm just curious what your take on that is, Eric. Isn't it an important place to be a professor in a law school right now?
Yeah, I think being a professor is a great and important place to be at any time, because you get, as you point out, to shape young minds. But especially now, following the murder of George Floyd and then the political uprising, and nationwide, I think universities and law schools, in part prompted by students like Nikki and Beatrice and the other Black Law Student Association members at places like Loyola Law School, all of us are being challenged to rethink the way we teach and what we teach. And Nikki and Beatrice, on behalf of BALSA, uh, made a set of demands of Loyola Law School, um, and and hopefully we are beginning the process of addressing it. I think
Mm.
one of the points that you raised, thinking about the criminal process, is an important one. So there's been some scholarship recently. A friend of mine, Alice Ristroff at Brooklyn Law School, just wrote a really fantastic article in the Columbia Law Review, uh, suggesting that the way that we teach criminal law, which is a mandatory first year class for all law students, it's tested on the bar exam in every bar in the country. And so it's really an introductory course for students to get sort of their first exposure to the law. Um, One of the ways that we teach that course is to focus primarily on violent crime. And as Alice points out, that gives a perception that all criminals are people engaged in violent acts. You might think of them as moral monsters who need to be locked away. And so when we think of the statistic, if we do, I mean, not every casebook includes a discussion of the practice of punishment, but if we think of the fact that there's 2.3 million people in federal and state prison, that 50% of those people are African American, that they're overwhelmingly black men, although the fastest growing group in prison is black women, that when they are first have their contact with the criminal justice system, they tend to be young, so between the ages of 15 and 25. That this is has a massive impact on the black community. So something like 1 in 4 people between the ages of 15 and 25 in certain states have contact with the criminal justice system, or the criminal process, as I prefer to call it. That's an amazing feature of the criminal law, but it's not something that tends to be discussed in criminal law courses. And so that gets to your point. When we see the 50% of people in jails and prison are African American, if you follow along with the first year criminal course, you're going to think, well, they're moral monsters who deserve to be there. And you may even think, thank goodness they're there for my safety. But it turns out that the criminal law casebook radically misrepresents the people who have contact with the criminal justice system. So one of the things I'm currently involved in is writing a casebook with 2 other people, Roger Fairfax and Bennett Capers, and that's going to be the first major casebook in criminal law, at least as far as we're aware, by 3 black men. I'm black British, they're African American. And one of the things that we really wanted to do with the casebook is think hard about including alternative crimes. So crimes against property has a significant impact. Victimless crime has a significant portion of the casebook. Things like so victimless crimes include things like gambling, sex work, drug possession. But in the property law context, we've included a couple of cases that really, I think, hammer home how the criminal justice system often doesn't protect the weak and vulnerable, but actually targets the weak and vulnerable. So one of the cases, it's a California case, features, I think it's a 6-year-old child who, certainly it's an elementary school child, who has got hold of their teacher's visor. And the case illustrates the law of theft and a particular part of the law of theft, two parts of the law of theft. One is that in order to steal something, you have to not only take it from someone, but you have to take it away from someone. So you have to move it.
Mm-hmm.
And then the second is there's a what's called a mental element. So you have to intend not to give it back. And in this case, the 6-year-old, just in having the visor on their desk and moving it around their desk, satisfies, according to the court, the movement element. And then the child is seen potentially with the visor in the hallway and can't find it, so loses it. And losing it, the court says, demonstrates an intent not to return, which is another element of the crime of theft. And so what's striking to me is, why would the teacher call the police? And why
Mm-hmm.
would the prosecutor decide to prosecute?
A
So this is a
6-year-old.
decision by a prosecutor. Yeah, by a prosecutor to prosecute someone. You know, even if it's a 26-year-old, it is an elementary school child, for the theft of a $6 visor. And so when we talk about the school to prison pipeline, um, that's it directly there.
It's
Another,
real.
oh, it's totally real. And then another case we included is an arson case. So arson is a destruction of property by fire. Property in the criminal law has to be a thing of value. Well, in this case, another school kid sets a fire in a trash can in a schoolyard. Not something you want to encourage children to do, but the major question in the case was whether the child destroyed any property, anything of value. It is, after all, trash in a trash can. The court says yes, and again, a teacher decides to call the police, and a prosecutor decides to prosecute the child, and a judge decides that this child deserves to go into the juvenile justice process for an act that, if it occurred in someone's backyard, would probably just get a wagging of the finger. So these are not moral monsters that are going to our prisons and jails and into our juvenile detention centres. These are kids playing with visors and playing with matches. And sometimes playing with matches is dangerous, but sometimes it's not. And so what we want the casebook to do, in part, is get the students to question who we're using the criminal law against, and whether the victims really are, whether there are victims here. Who's the victim here? The teacher losing a $6 visor, the school having to clean up the mess in the trash can, and whether it's actually the weak and the vulnerable that are being targeted by the criminal law system, in this case, to school kids.
So explain to me and the listeners exactly how is a case study book used?
So, so a case book is a collection of cases used to illustrate the elements of particular laws. So each law, so if you think of, for example, I want to teach you the law of theft. The law of theft requires, so the definition of theft is the taking and carrying away of some thing of value with the intent to permanently deprive the owner of their property. So we've got the elements of taking, of carrying away, which are acts, physical acts, and then a mental element, which is the intent to permanently deprive. And so so I could just tell you that's the statute, but what we do with casebooks is we use the casebook to go through normally one or two examples of each of the elements, so the elements of taking, of carrying away, and of permanently depriving, and getting the students to think a little bit about what these things mean, like how much movement does there need to be a carrying away? The answer in this case is not much at all. It just needs to move it around the desk. What sort of intent is the intent to permanently deprive? So normally It would be, me taking your wallet or purse in order to keep it for myself. Well, this child lost it. Is that really an intent to permanently deprive? The court, in the first case we discussed, says yes. And so what the cases in a casebook push us to do is hopefully think about not just the core cases, but also the boundaries of various laws and how we're going to apply them, and against whom we're going to apply them, and where all the cases, if we're thinking about theft, are things like someone snatching a purse in the middle of a street. That seems like quite a if not totally violent, although it could be violent, certainly very disturbing and shocking act. Like it offends our sense of safety. A child taking a visor and losing it doesn't seem to fit with that. And so if all the cases that we learn about are cases in which someone does something aggressive or violent, or something that clearly shocks our moral sensibility, then we're going to think that everyone who's in jail or prison has done something that is shocking or violent, and so they certainly deserve to be there. What we're trying to do is select cases that challenge the idea that they deserve to be there, in part so that we can then better serve the students, all students who need to think about what the purpose of the criminal law is, but also particularly the students who this summer said we want curriculum that's responsive to the issues of social justice that structure our society. And so what we want to help do is show some of the ways that the criminal justice system, and depending on your view, you're going to think it fails or it succeeds in deliberately targeting historically discriminated against people or people on the margins of society. So we have some cases that discuss, for example, people with mental disabilities and so on and so forth. The way that the criminal justice system targets transgender people is included in the casebook. And so what we wanted to do was respond to the demand that people are making nationally, but Nikki and Beatrice made on our campus to engage with systemic inequality. And I think this casebook does that. But even if you don't have a casebook that is geared around that, there's plenty of cases in the first year casebook that have facts that we often jump over, and that was one of, I think, the students' complaints. We jump over the facts that pertain to race or to gender or to class or to disability or to national origin and say that they're irrelevant to thinking like a lawyer. Whereas I think we at Loyola, and hopefully this is just good legal practice, need to see the whole person when we're thinking about how we represent clients or represent the state when prosecuting or defending clients, and recognize that justice is about more than simply following the letter of the law, but making sure that the law is used in ways that produce good outcomes. How do you benefit a student who loses a visor by criminally prosecuting them and having them go into the juvenile system? It just seems crazy to me.
So as a professor, your casebook, when it is ready, will be available to me to use as examples of cases in my classroom, right?
Correct.
But it's my choice whether or not I want to use it. Or is it required, or would it be a requirement in the school that this is the case book that we're going to use for these particular classes at this school? How does that work? Is it my individual choice?
Yeah, as a law professor, so this is one of the interesting features of the American legal system, which is different. So I'm Scottish. I studied law in Scotland and in the States. And in Scotland, basically, uh, uh, there's certainly a smaller choice of textbooks. And
Mm.
the sense I got was that um, there was a designated person on the faculty to teach property, to teach criminal law, and so on and so forth. So there was the standard book that everybody uses is a feature of the Scottish and English legal system. But
Mm.
in the American system, uh, there's much more choice, and so the selection of a case book is, for the most part, a personal decision by the professor, and the professor can even not choose a casebook and come up with their own materials. For me, the advantage of having a casebook, even though they are ridiculously expensive, so it's a bit of a burden on this on the student certainly, is that the advantage of having a bound set of materials is that the student um, treats that as authoritative. So
Mhm.
because they spend a lot of money on
Mhm.
a book that's put out by the legal casebook industry, they
Mhm.
think, oh, this is, and it has been, the scholars look at it and they give you feedback on the casebook, and um, uh, they say whether they would use it themselves and so on and so forth. So it's not like there's no vetting, but the students, I think, treat the casebook with a little bit more reverence than necessarily they should. Um, and so for us, I think it was important uh, to produce a casebook in order to intervene in this space. Now, there are other casebooks written from a sort of more liberal perspective, but I think ours is really pushing hard in the direction of selecting. A lot of the casebooks cover the same cases; they just cover it from different perspectives. I think, um, we include some of the standard cases, but we include a lot more, and so we give the professor a lot more choice in what they want to teach, um, and hopefully bring a perspective that will enable people who want to um, keep pushing forward through this moment the opportunity to do so using these materials in their class. But we can't mandate that
Mhm.
everyone in Loyola teaches from the casebook. I mean, I can
Well,
go
yeah,
around and knock on their doors.
right. But as you say, as you said, people who want to. So then the question behind all of that is, how do you change the mindset of the people who've been teaching this class in this way every day? And I've used this case book, and these are the kinds of things that I do, and I don't really even see that whole world you're talking about, and I'm not focusing on how do you change, how do you open their minds? How do you change that mindset? Because that's a
So,
requirement, yeah?
so one of the ways that we've done it at Loyola is by introducing a learning outcome, and as I think Nikki and Beatrice
Mm-hmm.
explained, the American Bar Association, which essentially regulates the standards at various law schools, has recently required law schools to come out with a set of learning outcomes, and then will every, I think it's 4 years or 5 years, goes to the law school and asks them to demonstrate that they have
Mm-hmm.
um, evaluated whether the students have learned what we've said they ought to learn. And so one of the things that's been going on across the country um, leading up to coming back on campus has been a rethinking of the syllabus and what students are offered, in part because students have demanded to be taught about race and class and gender and social justice. And one way that a lot of law schools, not necessarily all of them, but a sizable chunk, have responded to this is by saying what we're going to do is we're going to have a class on race in the law, and we're going to make it mandatory, so everybody has to take it. Of course, the worry is that if you just have one class singled out to discuss race in the law, and everybody has to take it, the students are going to think, well, um, that's 2 or 3 credits that I could be using to study tax law, that I'm having to study
Mm.
this, and I'm uninterested in that. So it generates some uh, um, uh, pushback from students who aren't particularly focused on, for example, a course on race. And in order to make it mandatory, um, unless you're going to hire a bunch of new professors, so every student has to take the class to graduate. Um, if it's a small class, a 10 to 15 person class, um, and you've got 100 people in the year, then you need um, you know 8 to 10 professors to teach that class. So the default is to have one 100-person class with one teacher, which means that you don't cover the materials particularly well, and you have a bunch of students who don't want to be there. And so we didn't think that was the way to go. And so the learning outcome that we adopted, which is that students will understand laws' impact on systemic inequality, we made mandatory for the first year classes and the required upper division classes, the second and third year classes. And those second and third year classes are evidence law, constitutional law, and the legal profession class, which is about essentially legal morality, the morality of lawyers in taking cases. And so I teach evidence. So the evidence professors had a meeting to discuss how we were going to do this, and some people are keener than others on changing their curriculum. Certainly, all of us professors feel like we're trying to squeeze as much as we can, and so a choice to include something is inevitably a choice to drop something else from the course. But a lot of it is ensuring that what we're teaching is really the practice of law. So
Yeah.
it actually enables us, because what we're talking about is law's impact on systemic inequality. So we're asking, what's society like? Who has power? Who doesn't have power? And how does the law help or hinder that? And so with the criminal law course, in the case bit, you can see that what we want to do is change the discussion from showing simply how the criminal law helps lock up moral monsters, yay criminal law, to thinking about, well, does the criminal law always target only those people? No, it also targets the weak and vulnerable. And so now we have to have a more complicated conversation. The other thing about the learning outcome is, which I think is actually in some ways the most powerful part of the learning outcome, is, as I like to say, if Justice Scalia rose from the dead and came back to teach at Loyola Law School, or Chief Justice Roberts decided to retire and came to teach at Loyola Law School, and the question is, would they be able to teach to the learning outcome? In other words, is the learning outcome inherently progressive? And the answer is, well, it's somewhat progressive in the subject matter, because we want the professors to focus on how the law impacts people in their lives. But Justice Scalia famously wrote the opinion in a case called Croson versus City of Richmond. It's a case that actually is somewhat relevant now, because it was whether the City of Richmond in Virginia could have a set aside so that whatever it was, 10% of municipal contracts went to contractors who were run by or predominantly African American or other people of color. And so, with President Biden making mandatory the vaccine, these sorts of mandatory set-asides or mandatory orders by governments are back in the news. And Justice Scalia essentially says something like, this is terrible because of the impact it will have on society. The city of Richmond is a majority black city, and so the worry is that if black people get in power, they'll do the same things that white people did, and so racially discriminate. And so, you may or may not agree with that, but at least he's having a discussion of the law's
Yes.
impact on society. And so, what I like about the learning outcome is whatever perspective you teach it from, the one thing you can't do is ignore it.
Mm.
If you ignore it, the student has the right, because it's a mandatory learning outcome, to call you out as a professor
Mm.
on it. And so the learning outcome empowers the students to raise the issues in the class. They're no longer taught that it's not thinking like a lawyer to think about race and class and gender and disability and all these things, national origin. Instead, these are things that the law has an impact on, and we have an obligation as law professors to address. Now, um, if you're a liberal, you're going to address it from a liberal perspective. But if you're a conservative, you can't just ignore it. And the dirty secret is that conservatives don't just ignore it. Often they, like Justice Scalia in Croson versus City of Richmond, come up with their own version of law's impact on society, one that you and I may disagree with, but other people may agree with. And so, I think having an inclusive classroom means that we get to engage with all perspectives: conservative, liberal, in the middle, undecided, uninterested,
Mm-hmm.
and ideally empower students to have a voice in that process. And that's what I'm hoping that
Mm-hmm.
this does.
That's
Now, the big
beautiful.
difficulty then is how we change our teaching style, um, which in law schools has historically been one in which the professor dominates the students, to deal with this new zone of student empowerment. And I think that is where things are likely to be difficult, where even well-meaning professors are going to struggle with their new role in the classroom.
Mm-hmm. Well, I just pray that all of that goes really well because it's and your case book sounds wonderful. So on all of that, and
Well, I mean, I think
I'm gonna want to stay posted on what's happening and how it's going because I really it's something I really care about. It's something I really care about having nothing to do, no connection with it. I really care about it. Go ahead, you were going to say
well, but
something.
I think it speaks. Yeah, I think it speaks to a bigger problem in society. So there's two ways of doing. I mean, there's a lot of ways of doing the work of becoming more inclusive. One way, though, is to change the syllabus,
Mm-hmm.
or in different workplaces, it's to change how we address each other. In a
Mm-hmm.
museum, it may be to bring out some exhibits and put other exhibits away. I find
Mm-hmm.
museum Twitter to be quite an interesting place at the moment, where people are
Mm-hmm.
discussing how to deal with this. Um, so, I mean, you can think of a whole bunch of superficial ways of doing it. If you're in a law firm, what you do is you um, set up an equity and inclusion committee and make sure that your brochures include people of color. That standard way that we're all familiar with of sort of um, riding out the storm. Um, for us, having empowered the students, the challenge then becomes doing the hard work of learning how to teach differently. So it's not just writing a different curriculum, it's about interacting in ways that genuinely respect the people with whom we're learning with and teaching to. And I think that's something that isn't just limited to law schools, but that
No.
um, speaks to this moment. And so um, le- learning empathy and respect, recognizing who needs to do the work to change. So
That's the
not our
hard part.
students, right? So I don't want our students to bear the brunt of um, badly thought out pedagogy in which
Mm,
all you do when you want to address an issue you perceive as a black issue, or an issue you perceive as a woman's issue, or an issue you perceive as a prosecutor's issue,
mm,
that you call on a black person, a woman, or someone you perceive as conservative. That's not the way that it should go.
mm,
Um,
mm.
of course, all too often it is the way that it goes. And so the real question, I think, for uh, Loyola is how well we as a faculty are going to do in, as it were, reteaching ourselves. And I think that that's a really important and powerful question that goes beyond the law school, but even just
Yes.
located in the law school, it's a really powerful and important question. And you know, some people are better placed than others to embrace new stuff. Um, some people have sunk a lot of time and effort into their materials and into their teaching
Mm,
style.
mm,
It can be difficult to change. Some people may not be motivated to change. They may think that everything's hunky dory, and why should they do anything different?
mm,
And
mm.
those are difficult conversations, and they're conversations that need to keep going. But I, I'm optimistic that we're having these conversations. I know that I think you spoke to Kathleen Kim a
Mm,
while
yes,
ago, and
yes.
I think she's really been supportive of the students, but is being supportive of the faculty as well.
Mm,
There's certainly lots more work that needs to be done,
mm,
um, and there's been some, fairly good, sometimes passionate discussion about how we're going to do this.
mm,
But again, um, I think the mission of Loyola Law School is a social justice mission. It's right there in our mission statement. And so including an expansive, inclusive understanding of social justice within that mission is really important. And I'm grateful to our students for pushing us to do that.
yes, yes. I am too. You know, while I have you here, Eric, in a nutshell, what's your take on reparations?
Haha.
Like
In a
that's a
nutshell,
whole
that's
nother episode.
yeah. So so just so you know, I have a fairly long history with reparations. So in 2002, 2003, I was a fellow at Harvard Law School when Charles Ogletree was tasked by Randall Robinson with coming up with a reparations lawsuit. Um, and I'd been Professor Ogletree's research assistant before, and then I'd gone and clerked for a couple of judges, worked in a law firm, and I was back doing a fellowship trying to become a law professor, and needed some cash. And so he said, well, look, I need a research assistant. Why don't you go and come and work with us on the reparations coordinating committee, which was him and another great lawyer, Ajwa Ayatoro, who's with in Cobra and is now an emeritus law professor at the University of Arkansas. Anyway, Ogletree and Ayatoro were trying to come up with a lawsuit, and Ogletree went out to Tulsa, Oklahoma to give a talk and came back telling us that there were 40 survivors of the Tulsa race massacre still alive, and who wanted legal representation. And it turned out that there were 125 that we found still alive, and we filed a federal lawsuit on behalf of them. We had Johnny Cochran join the lawsuit, um, uh, a bunch of other fantastic lawyers participating as well, and so that's when I got involved. I worked on that lawsuit. I helped draft the complaint with a few other people, Adjoa uh, being one of them, and Suzette Malvo, who's now at Colorado University, being another. Al Brophy was a sort of an expert on the Tulsa Race Massacre, was a sort of legal historian who was advising us. And so we filed the lawsuit, went to federal court, it got dismissed, which means that the court denied the claims. But it was a big moment, I think, for reparations. So I worked on that lawsuit, and now I'm back in court, state court this time, again representing the last three living survivors of the Tulsa Race Massacre. And this time we're alleging public nuisance. So this is just giving a little bit of my background with reparations. So what I think reparations is reparations are a transformative justice remedy for a group-based intergenerational wrong. So the basic idea is some group, and in particular I've focused on African Americans, has been targeted by some person or entity for an injury, so slavery, Jim Crow, that has an intergenerational effect. And thinking about it this way has a few advantages. First of all, by focusing on group-based oppression, essentially, we can get past the idea that the people to whom the harm was done have died, or the people who did the harm have died. Because the harm is to the group, and the group can continue over time. You know, just think of the Los Angeles Rams are not the same team from the 1950s. It's a whole different set of people, but it's the same. You know, it's still the Los Angeles Rams.
Right,
it's just a different set of individuals that are the Rams. So that's one thing that I think helps is you can see how it's the same. You know, the group is targeted as a group, even though different individuals come in and out of that group. The second thing I think that reparations is about is the remedy is so what reparations is to empower the victims of intergenerational group-based oppression to determine for themselves how things are going to go for them in the future. Now that sounds a little bit wishy-washy, but so am I in favor of payments to individuals as a form of reparations? Sure. I think one version of reparations is definitely you harmed me, so you owe me. You took my money and my land, so you need to give me back my money and my land. So we've seen that happening in Los Angeles just recently, where the city took a beach property away from some
Yeah.
African Americans and is now
Yeah.
giving it back.
Yeah.
But by focusing on the idea of, so if we think about slavery, or if we think about Tulsa, so think about the harm done in the Tulsa race massacre. So one, there are a group of people, so we have three living plaintiffs, Leslie Randall, Viola Fraser, and Mr. Van Ellis, Hughes Van Ellis. So they were victims of the race massacre. Their house was burned. They were terrorized. Their property was taken. The people who took that property burned those houses, which includes the city of Tulsa. The city of Tulsa police force, the city of Tulsa sheriff's department ought to give that land back and ought to pay for their property. So that's direct monetary payments. But the act of mass racial violence, terror, burning down 35 city blocks to the ground, killing upwards of 300 people, running 3,000 people out of town, so turning them into refugees who fled from the city. The ones who stayed were kept in detention camps, paroled essentially into the custody of their employers, so it was like a form of slavery for a few days, and then forced to live in Red Cross tents for the next 6 months. This is a mass act of terror, and its effects are still felt. And to the extent that the white citizens of Tulsa are continue to use the system of racial oppression to keep themselves up and keep other people down. These are new wrongs. Like it's not just the it's
Right.
not just the people that burned the house down
Right.
that have done a bad act. It's the current citizens who refuse to allow the black survivors and their descendants to re-empower themselves that continually harm the people of Tulsa. And you can say the same about slavery and structural
Absolutely.
racism more generally. So for me, reparations is a complicated thing because on the one hand, there's a historical wrong, but the historical wrong also produces contemporary wrongs. And each of those wrongs deserves a remedy. And then the final question, I think, I'm coming to see as quite profound is so reparations often is associated historically with black nationalism. And you might think that one of the really important questions raised by black nationalism is something like, how do you expect us to continue to go along with you, to live with you in
Mm-hmm.
community?
Mm-hmm.
And and I think that is a core question of the transformational justice aspect of reparations. Um, the question is, given the harm that you've done in the past and how you continue to harm us in the present, um, what we need is a transformation. And who knows what that transformation is going to be? It may be one in which we continue to join together in an American, a larger community. Certainly, the survivors of the Tulsa Race Massacre, when they testified in Congress, that was, they said we're proud to be American, and we believe in the American project. But there's also this, other aspect of it that says, but um, you know, we can't guarantee that reconciliation is going to be the ultimate outcome. It depends on how you treat us and how you support us. And I think that that's a really, it's a difficult question. It's a question that, different communities face in different ways all the time. But I think that in some ways, that is what is a question that reparations really presses hard upon, because it points out that the crude version is you owe us. The slightly more sophisticated version, I think, is you have to do something to show us that you respect us and that we can go on together as mutually uh, respectful equals in community together, and
Mm-hmm.
simply saying, it happened a long time ago,
Yeah.
tough luck.
Yeah.
It turns out it's actually quite disrespectful, and
Quite.
it denies community in important ways, and so I think there's. I realize it's a very long answer to a very short question, but this is all my way of saying that reparations is quite a complicated
Mm-hmm.
business, and requires a lot of thought and activism if it's going to be done right.
Eric, I'm so grateful. I'm grateful that you exist. I'm grateful that you, this individual, Eric Miller, I'm grateful that you exist because you're doing so much. You care about so much. You're processing so much that the world, not just this country, the world needs right now. Talking about we need each other. What you're bringing, what you're providing, what you're focused on, and what you're bringing people together to assist in doing is beautiful. Or what you're aligning with yourself and being brought into. It's beautiful and it's necessary and it's so powerful and it gives me hope because man, it's hard being a black person in the United States of America. It just is. Even if your life doesn't look difficult in comparison to what other people's lives look like, I don't care how happy and happy go lucky your life looks, you're still black in America. And it's a perspective that it's really hard to understand if you don't live that life or even have an alignment with that life. So I'm grateful to you. I could do three more episodes with you, honestly, because you have so much. We didn't even get into police reform. But next time, maybe.
Yeah.
I'm so grateful to you. I really appreciate your being here with us today and
Oh,
taking
you're
your
welcome.
time. Hmm.
I enjoyed this
So,
conversation.
yes, me too, very much so. We will speak with you again soon.
Great. Thank
All
you.
right. Thank you, Eric. Have a wonderful rest of your day.
Thanks. Bye.
Bye.